All right, guys. Hi, welcome back. Attorney Steve Vondran. I had a friend that asked for more information on this Donald Trump gag order and what it looks like and what is a gag order. So I thought I would do another episode of the legal side of politics, with Attorney Steve. All right. So, Trump's involved in several different lawsuits and investigations, criminal complaints and whatnot. This one deals with the United States of America versus Donald Trump. This is a criminal action. This was dealing with the January 6th insurrection, as they called it. And I'll just go ahead and read it here for you so you get a look at what is a gag order. Now, traditionally, you really don't want to gag too many people. There is a thing called freedom of the speech, First Amendment rights, and in criminal proceedings, all defendants are considered and presumed innocent until and unless proven guilty. But there are circumstances where courts have done gag orders. And here's what happened in the Trump case. So let's take a look. Now, this is fresh off the press. It just came into the court docket. So I want to show you to this. Not too many people have actually seen this, but it's real quick. It's a couple pages here, so I'll read it to you real quick. For the reasons set forth below, the court is granting in part, denying in part the gag order. Okay. Under binding Supreme Court precedent, this court must take such steps by rule and regulation that will protect its processes from prejudicial outside interferences. So they cite a 1966 Supreme Court case. The First Amendment, that's what I just talked about, does not override that obligation. Freedom of discussion should be given the widest range compatible with the essential requirement for the fair and orderly administration of justice. So what the court's doing here is balancing it. Federal court judge is balancing the right of free speech versus fair and orderly administration of justice. But it must not be allowed to divert the trial from the very purpose of a court system to adjudicate controversies, both criminal and civil, in the calmness and solemnity of the courtroom according to legal procedures, okay? Although litigants do not surrender their First Amendment rights at the courthouse door, those rights may be subordinated to other interests that arise in this setting. For instance, on several occasions, this court has approved restriction on the communications of trial participants where necessary to ensure a fair trial for a criminal defendant. Here, alternative measures such as careful voir dire, that's choosing your jury sequestering, and cautionary jury instructions are sufficient to remedy only some of the potential prejudices that the government's motion seeks to address. In order to safeguard the integrity of these proceedings, it is necessary to impose restrictions on public statements by interested parties. Undisputed testimony cited by the government demonstrates that when defendant has publicly attacked individuals, including on matters related to this case, those individuals are consequently threatened and harassed. So the court has an interest in guarding against harassment of potential witnesses mainly, and also the court participants, okay? Since his indictment and even after the government filed the instant motion, defendant has continued to make similar statements attacking individuals involved in the judicial process, including potential witnesses, prosecutors, and court staff. Defendant has made those statements to national audiences. Remember, Trump does rallies, and he has Truth Social, I think they call it, using language communicating not merely that he believes the process to be illegitimate, but also that a particular individuals involved in it are liars or thugs or deserve death. The court finds that such statements pose a significant and immediate risk that witness will be intimidated or otherwise unduly influenced by the prospect of being themselves targeted for harassments or threats, and to attorneys, public servants, and other court staff themselves will become targets for threats and harassment. And that risk is largely irreversible in the age of the internet. Once an individual is publicly targeted, even revoking the offending statement may not abate the subsequent threats, harassment, or other intimidating effects during the pretrial as well as the trial stages of this case. The defense's position that no limits may be placed on the defendant's speech because he is engaged in a political campaign is untenable, and the cases it cites do not so hold. The circuit courts of both the United States v. Brown and United States v. Ford recognize that the First Amendment rights must yield to the imperative of a fair trial. Okay, so there's some case law citation by the court. Unlike the district courts in those cases, however, this court has found that even amidst his political campaign, defendant's statements pose sufficiently grave threats to the integrity of these proceedings that cannot be addressed by alternative means, and it has tailored its order to meet the force of those threats. Thus, limited restrictions on extrajudicial statements are justified here. The bottom line is that equal justice under the law requires equal treatment of criminal defendants. Defendants' presidential candidacy cannot excuse statements that would otherwise intolerably jeopardize these proceedings. Accordingly, in pursuant to Local Criminal Rule 57.7c as in cupcake, it is hereby ordered that, here's the order, all interested parties in this matter, including the parties and their counsel, are prohibited from making any public statements or directing others to make any public statements. For example, that would be Donald Trump's kids. Okay, so I've seen people say, well, Trump's kids will just do it. And it says here, or directing others to make any public statements. That target one, the special counsel that's prosecuting this case or his staff. Two, the defense counsel or their staff. Three, any of this court's staff or other supporting personnel. Or four, any reasonably foreseeable witness or the substance of their testimony. This order shall not be construed, we're almost done here, this order shall not be construed to prohibit defendant from making statements criticizing the government generally, including the current administration or the Department of Justice, statements asserting that defendant is innocent of the charges against him, that's free game, or that his prosecution is politically motivated, that's free game, or statements criticizing the campaign platforms or policies of defendants' current political rivals, such as former Vice President Pence. Vice President Pence, I understand, may be a witness and is also running against him. In addition, the sealed versions, there you go. So anyway, here's the Judge Chukin signing the order. There it is. That's a gag order, folks. That's what a gag order is. And if you don't follow it, and again, sometimes these can be a little vague where you kind of go, can I do this? Can I do that? You have to walk a narrow line or the other party can file contempt for contempt of the proceedings. And that could be sanctions or even jail time if it's serious enough. So there you have it. Trump has appealed this. This was just filed. And I notice in the docket as well, there's also an appeal to the United States Court of Appeals in the D.C. District. Okay, so that's the current standing. I will keep you posted on seeing what happens here. But if you want to know what is a gag order, yes, you have free speech, but yes, there are overriding interests. Everything in law, many things get balanced. And in this case, the court apparently tried to narrowly tailor the order to allow some free speech, but to disallow some other free speech. And there you have it. Okay, now you know what a gag order is. Have a great day. General legal information only, not legal advice. Don't forget to subscribe to our channel. We're growing fast every day. Who else is bringing you the great legal news of the day? Attorney Steve. You can find us on the web at attorneysteve.com, civil litigation. Have a great day. Got to run. Bye now.